might have seen the article that was very well done by the Sarasota Herald Tribune last Sunday, talking about how one local assisted living, independent living, senior living facility would like to work through this issue of how could they be in a position to dispense medical cannabis to their residents and therefore enhance their lives through better living. And that is Alderman Oaks, which is located down south of downtown, just north of Mound Street and just a little east of Orange Avenue. And they have been reaching out over the last year or so, I think somewhat inspired by our last forum, quite frankly, and have brought someone to our attention who's our next speaker. And that is someone who's going to tell us about the legal implications of all this, Attorney Ricky Strong. Ricky has a bachelor's degree in psychology from Florida State University, has an MBA and also a focus on management from Mercer University, and received his Juris Doctor, his law degree from the Florida Agricultural and Mechanical University in Tallahassee, Florida. Ricky has served as an attorney for the Florida Department of Health. He serves as an adjunct professor at Florida A&M. And is an associate attorney with the office of Jeffrey S. Howell in Tallahassee. And here to help us understand the status of medical cannabis in senior living communities, ladies and gentlemen, please join me in welcoming Ricky Strong.
Make me sound so important. So first of all, thank you guys for inviting me to speak here today, and I always have to start with this disclaimer that my law firm, we are not pot attorneys, as we have been gotten, and people are starting to label us as, oh, these are the pot guys. I'm like, no. We're actually healthcare. Our firm focuses mostly on healthcare. We are a healthcare firm headquartered in Tallahassee. My office is in Orlando. We're soon to be opening up an office here locally in Sarasota with my associate Tom Buchan, who's here joining me today. And so how did we get involved in medical marijuana? I have to say I've spoken on this topic now for about 10 times over the past year, and I'm actually totally convinced. Like, I had no clue. I grew up where, you know, kids smoking pot were, you know, who were the bad kids. So I have learned a lot, you know, through the past year, speaking on this topic. So how we got involved in it is that my firm, we are associate members of FALA, which is the Florida Assisted Living Association. And so last year at their annual conference, which was in Orlando, they'd asked my law partner Jeff and myself to speak on this topic, and of course we had no clue or anything about what medical marijuana was. So that's why we have law clerks, and so we put Tom together to do some research on this stuff because I don't know anything. So we quickly got up to speed, and then we put together this nice presentation, which was professionally done. I didn't do this, PowerPoint, and so hopefully I cannot be so boring right before lunch. So this is kind of just a quick overview of what we're going to discuss, just kind of define marijuana and the term medical marijuana, just a brief history of marijuana, which we've already discussed a little bit today, the Florida law, the requirements and the use of medical marijuana, how federal law conflicts with Florida law, and the issues and challenges in which ALF owners, nursing homes, and other senior living places are starting to have with this particular issue. So let's start with the U.S. Federal Code definition of the term marijuana. So basically it means all parts of the plant cannabis, which we've been discussing, that all parts of the plant is usable. Whether growing it or not, the seeds thereof arise and extracted from any part of the plant. Every compound, manufacture, salt, derivative, mixture, or preparation of such plant and its seeds. So this is a very, very short version of the definition that we just basically cut the meat out of it, just to kind of give you an idea, as has been discussed earlier today, the entire plant can be used, which I didn't know that until now. So living and learning. The history of cannabis, I think I actually accidentally cut out one of the slides. After that's the medical, that is the marijuana term that is in the federal code. So within the Florida Constitution has now carved out what is considered medical marijuana because it's not the same. that's how we're able to disguise it as it's another product as medical marijuana, because medical marijuana has now been redefined by the Florida Constitution, which differentiates it from the federal code of marijuana. So that's how we're able to get it into the Florida Constitution, which I think I actually didn't cut that slide out because I was trying to cut it down. So here's a quick brief history of cannabis. As we stated earlier, it's been using it in the United States in the 1700s, 1800s. As we've also discussed earlier today, the use of the plant is very industrious. It can be used, for bags and clothing and a house. I didn't know that until today, and I've spoken on this a bunch. And so that is very interesting. That is a very industrial, useful plant that was actually legal up until 1937, when the government decided that we're just going to tax it to death. We love the government. So the best way to outlaw something is to just tax it. If you're found with it, we'll just tax you to death or end up in prison because you can't pay all of the taxes. So that's when cannabis actually became illegal, was in 1937. So obviously when you fast forward to 1970, the Controlled Substance Act, which was created, the federal regulation and the classification system, which, as we've discussed also, cannabis is now considered a level 1 medicine. So that is how it got classified, and that is why it is now illegal federally in the country. So a brief history of Florida medical marijuana history. And also, as discussed earlier, the Compassionate Medical Cannabis Act was passed in 2014, which was the Charlotte's Web version of the law, which was so eloquently discussed, the Charlotte Web video and all that stuff earlier today. So I'll skip over that part. Amendment 2 was approved by Florida voters in November 8th, 2016. How many of you guys voted for it? I did too. Yeah, and as we know, it passed by 70-something%. So a lot of people voted for it. I mean, it expanded across the House. And I've spoken on this topic throughout the state, from the Panhandle to Miami, and I just overwhelmed with the amount of people when I asked that question. Everybody raises their hand. So it is very unusual that you can get that type of percentage of people to all agree that this should probably be legal in the state. So that allowed the state of Florida to be able to amend the Constitution. So Senate Bill 8A passed in 2017 that established a regulation under the Florida Department of Health. I used to be an attorney for the Florida Department of Health, and I will tell you, they were not prepared for what was going to happen. The Florida Department of Health, they regulate medicine, the physicians and licensed healthcare professionals, they were not prepared for what this was going to be. And so even under the guise of environmental health, which also falls under the jurisdiction of the Florida Department of Health, they were attempting to write a lot of the rules because it was somewhat loosely related. And so there's all these rules and things that were being promulgated, even during my time in Tallahassee, that when you were writing these things, you were like, some of this stuff is not even constitutional. They were just pulling stuff out of the air. But I'm not going to say that on the record. But there were a lot of people that just didn't know, because there was just such a gray area of what do we do, how do we promulgate rules in order to start regulating medical marijuana. But it's an ever-evolving situation in Tallahassee, as I'm sure everybody's aware of. So anyway, so Senate Bill 8 passed and established the regulation for medical marijuana, which falls under the Florida Department of Health. So what is the law? Is it a medicine or is it a legal drug? In Florida, even right now, it's still both. It is considered a medicine and it is also still illegal federally. So that's where you start getting to the issue. So let's go into the federal law. Marijuana is illegal. It is a Schedule I controlled substance. Marijuana cannot be safely used even under doctor's supervision, and that comes directly out of the United States Code, which is still active. However, Florida law says the Constitution and the statutes will allow for the term medical marijuana. So therefore, we go back to the actual definition of what is medical marijuana. And so that's how we're able to fit into the narrow parameters with the specific use for quote-unquote medical marijuana. Again, non-medical use is still a crime. So if your grandson scores a bag on the corner, it's still illegal. So you gotta get it the right way. So yeah, non-medical use is still a crime. So I always like to put that out there because I know quite a few people that scored that way. Not myself. Okay, Florida's Constitution allows for the use of medical marijuana. This is for individuals with debilitating medical conditions as determined by a licensed Florida physician. This allows for the caregivers, if you need a caregiver, to be able to assist the patient's medical use of marijuana. Again, the Florida Department of Health shall register and regulate the centers that produce and distribute the marijuana for medical purposes and shall issue identification cards to those patients and caregivers. This applies only to Florida law. The question always comes up, well, what if you drive through the state of Georgia, through Tennessee, what happens? It's invalid. It only applies in the state of Florida, and when you cross state lines, it really creates an issue. If you're going on vacation or you're going somewhere for the holiday, you got your certification, what happens when you cross state lines? Well, my suggestion is hide it as much as you can in the trunk of the car. What you got to do, just in case you get pulled over for a speeding ticket, because every state it varies, so you just don't know what you're going to get. It depends on which cop pulls you over too. So I mean, there's just way too many variables that come along with that. So again, the Florida Constitution does not immunize the violation of federal law or any non-medical use, possession, or production of marijuana. I'll give you an example. I have a client who is a real estate agent who has a certification, who was out visiting his parents in the state of Texas. And he got pulled over for speeding, and guess what? He had marijuana on him, and he got arrested. So that triggers all these other things out in Texas. Then the Florida Board of Realtors came in and said, oh, you had this arrest in Texas for having marijuana. So we're going to take your real estate license. So I have to go before the board. My client has the certification in Florida. However, it is not valid in Texas. So when he provided it to the Texas officer, he didn't care. So he still got arrested. So yeah, you do have to be very careful when you cross state borders. It's particularly in certain states that I won't name. Yeah. So, the Florida statutes. So, the physician certification process. So, a physician must be a qualified physician with an active, unrestricted license. They must complete the 2-hour course and subsequent examination that is offered by the Florida Medical Association if they are a medical doctor, and or the Florida Osteopathic Association if they are a DO. They must complete the course and pass it every 2 years. And again, this comes directly out of the Florida statutes. So the interesting thing here is that the physicians that are able to provide certification, they must have an unencumbered license. As I stated earlier, my firm, we represent all things healthcare, including physicians. There are a lot of physicians that have encumbered licenses, and I won't go into why, but they have restrictions on why they can't do certain things. So if they have any kind of restrictions like, boundary issues with female patients and things like that, you can't do the certification, you can't certify any of your patients for the medical marijuana. So they must have an unrestricted, unencumbered license, which a lot of physicians actually do have encumbered licenses. So it's very narrow. So, Section 381 of the Florida statutes requires the Department of Health to regulate medical marijuana treatment centers, which are MMTCs. The patient has to be diagnosed with a debilitating medical condition, which has now been expanded, must have a physician certification, and must obtain a valid identification card that is issued by the Florida Department of Health. If that person needs a caregiver of the patient, that person also have to register with the Department of Health and have an identification card in order to distribute or administer the medical marijuana to their loved one. This is just a quick summary of how it goes. So the physician diagnoses the patient with the qualifying condition under the statute. Obtain written informed consent from the patient. So informed consent is always needed for any type of procedure. I'm sure if you've been to any document in the past, you've all signed informed consent forms. You may or may not know it. Whether they describe to you what are the uses and benefits and what are the alternatives to whatever treatment that they're prescribing to you. That document must enter that order into the medical marijuana use registry that is run by the Department of Health. The patient must apply for the card through the Department of Health, and they must fill out an order form, which it goes to the dispensary, which are also operated by the Department of Health. And those MMTCs are approved by the Department of Health. We had a list of debilitating qualifying conditions earlier in one of our presentations. Mine's a little more extensive, which lists practically everything. And so I always like to point out chronic non-malignant pain. I would say whatever that is. So, which basically covers everything under the sun. So if you have a physician that has a certification and you have evidence, you can't just show up and say, oh, I have chronic non-malignant pain, I want medical marijuana. You do have to show that there is some type of consistency, that you have struggled with some of these qualifying conditions, which must be properly diagnosed and put into your charts in order to qualify for the conditions. So again, any of these particular conditions would qualify you for the medical marijuana. The caregiver. This is the biggest issue, or one of the biggest issues that has been presented by a lot of my clients in nursing homes and assisted living facilities. So there's so many people that are now getting qualified for the card. A lot of people are showing up in assisted living facilities, nursing homes, and other healthcare facilities that have the certification for medical marijuana. Obviously, if we're living in senior living, some people are not able to administer the medicine themselves. So they must appoint a caregiver to come in to give them their medication. The problem is, one, the caregiver has to be over 21 years or older. They must be a resident of Florida. So, as you know, everybody retires in Florida. What if your son and your daughter and everybody else lives in New York? How can they be a caregiver? They can't. So let's start with that problem. They have to pay $100. They have to pass a background screening, a level 2 background screening. Have any of you guys ever had a level 2 background screening? It's very extensive. So even if you got busted when you were 16, it's going to show up in your background. And if you've got an issue in your background at any point, you're not going to qualify to be a caregiver. So my firm, we represent a lot of people with level 2 background checks, as Tom can tell you. Stuff that pops up from 1978 because of, they were doing something. Oh, you can't be a caregiver, or you can't work in healthcare. I mean, it's absurd. Obviously, one, if the person is in hospice, they have a little bit more leeway with the caregiver rule, but not a whole lot. The biggest issue with the caregiver is that you cannot have more than one patient. So, the issue with my clients, the assisted living facilities, are, can I appoint staff to be the caregiver? Yes, but it's going to run up your cost exponentially if you've got 50 patients with certification, which means you've got to have one person per patient, so you're going to have 50 people on staff just to give medical marijuana to your residents. So that is the biggest issue. I'm not even sure why that's even in the rule, why you can only do it for one patient. I'm not sure why that's in there, but that is the most pressing problem that a lot of the nursing homes and assisted living facilities are having, just to have a person to provide the medical marijuana to the residents, because they're not going to meet the requirements, or they're not going to have enough people to serve as a caregiver. The caregiver also cannot receive compensation other than their actual expenses. So in essence, you can't just pay people just to run to the MMTC to pick up your medical marijuana and bring it back to the nursing home. You just can't. I don't get that, but that's what the rule requires at this point in time. So let's get into the legal question. Healthcare facilities also have to keep in mind that although medical marijuana, quote unquote, is not a medicine, it's not FDA approved, it's not FDA studied, therefore it is not considered a medicine. However, HIPAA still applies. So you still have to attempt to provide the same level of privacy to your residents that have the medical marijuana. So it can create an issue a lot of times. Because marijuana is not, in Florida right now, is not considered a medicine, if you own an assisted living facility, one of the requirements is that all of the medication for all your residents are to be locked away into a separate location so that it cannot be accessible by the residents. Marijuana doesn't fall under that category, so the question becomes, where do we put the medicine? My suggestion has always been allow the resident to keep it either in their room. If they have a caregiver, the caregiver probably should keep it themselves, just to alleviate any kind of issues that you might have with, what happened to, the oils or the edibles or now the smokable, because these things can tend to disappear. So I always come at it as representation for my clients that I'm here to protect you, and so you don't want to get into those issues. But at the same time, there's this balance of protecting the privacy of the resident, even though the resident themselves still have the marijuana in their room. So that's just one of the issues that have come up in the past. This is another part. This comes directly again out of the Florida Constitution. Nothing in this section shall require accommodation of on-site medical use of marijuana in any correctional institution or detention facility, those are jails by the way, or place of education or employment, or the smoking of medical marijuana in any public place. So there's a lot of stuff, a lot of times you see things in Tallahassee and go, why do they group so much stuff into one particular provision of the statute or the Constitution? So in essence what this means is, so as far as what I advise my clients, the issue that they're having in nursing homes and nursing homes and assisted living facilities is that, what if you have staff members that now qualify and have the certification? You're not required to make accommodations at this time, as the way the Florida Constitution is written, to make accommodations for those particular employees if they have the certification. Because here's what happens. A lot of times, those employees are licensed medical providers, which are licensed to the Department of Health. So, example, I have the certification. I don't, I'm just using it as an example. If I have the certification, I come to work and I have medical marijuana in my system, and today is the random testing day for everything, for drug testing for all healthcare professionals, and boom, I get popped, and now I'm going to get an administrative complaint filed against my professional license, which also can affect the facility, because now the Agency for Healthcare Administration, AHCA, may come in and say, you've got employees that are now in violation because they're coming to work, quote unquote, high. Because there's no differentiation between medical marijuana and marijuana. As long as it's in your system, that's what the law says. So if it's in your system, you're probably going to end up in some type of legal administrative issue with the licensing board or with the state. So a lot of times, again, there's no requirement to accommodate just because someone has the certification. So which the question becomes, will that lead to discrimination for employees who have the medical marijuana card? And yes, it is potentially could become a discriminatory type of situation. The problem is that you can't sue under ADA because ADA is a federal law. So therefore, you can't say, I am being discriminated because I have a debilitating condition, which I've been prescribed marijuana. I got fired from my job. You can't sue under ADA because it's a federal law. No, that's wrong. So, also, the smoking of medical marijuana in a public place. That's the news issue now that the smokable marijuana is legal, which I wasn't sure why it wasn't in the beginning, but now it is. So, a lot of places are now having to start to consider whether or not they're going to designate smokable sections. It's sort of like back in the day when you used to go to the restaurant, you want smoking or non-smoking section. I forgot about that. But if you've got the smokable marijuana, a lot of places are having to contemplate how do you deal with that particular situation, because if one person's sitting on their patio and they're smoking, and then their neighbor next door, they start complaining because they smell it, you're going to have a whole host of issues. So what I'm starting to see a lot of people is to just designate smoking areas within their facilities. Not necessarily senior facilities, but other types of places of employment that this is coming up. Again, correctional institutions, detention facilities, place of education. I'm from Orlando, and so I've done this presentation in Volusia County, which is in Daytona area. And so the school board, they're actually adopted and put in place. They had to revise their entire policy on drugs, because all public schools are drug-free zones. So therefore, you can't have marijuana on a drug-free zone. So they've actually gone ahead, and I'm seeing a lot of other counties in the state are going back and trying to revise their drug-free policy to accommodate those that do have the certification. There's no reimbursement from insurance or government. So if you're certified for medical marijuana, obviously you can't bill the insurance company for it. So it is a cash-based business only, which I'm not sure if that's going to change at some point in the future. It would have to federally be decriminalized, because insurance companies, in particular Medicaid and Medicare, are not going to pay for the medical marijuana, which can become a taxing issue for those that need the medical marijuana but may not actually have the money to pay for the certification, to pay for the doctor's visit, which is like $175 from what I've been told. And then you got to pay for the actual medicine itself. So it's not a cheap alternative if you're elderly and you're a fixed budget. Where do you come up with the funds to continue to pay for this stuff? And you have to continuously be certified. You have to continuously pay for the medicine. So it just becomes a financial burden for a lot of people. Hits leads to hits. Nothing in this section shall permit the operation of vehicle, aircraft, train, or boat while under the influence of marijuana. So what that means is that there is no breathalyzer, no pun intended, for marijuana, like there is for DUI and alcohol. So the many times that I've spoken on this, a lot of times there's members of law enforcement, and I will reach out and say, what do you guys do? So from what I've been told is that even when there is a particular situation where they suspect that someone is under the influence, there are other means in which they can make that determination that this person is under the influence of either alcohol or marijuana. It's sort of like a lot of people, they get pulled over for DUI, drinking while under the influence of alcohol. There's this myth that I've heard amongst other people that, oh, just don't blow into the breathalyzer, they can't prosecute you. That is not true. So don't do that, because that's actually an automatic suspension of your driver's license. So, but law enforcement, they will make their determination based upon other things that they feel that they think that you're under the influence. And of course, lawyers would love to jump on top of that and go, well, how did you make this determination? Did this person walk a line? But if somebody, suffers from, some type of medical condition, they may not be able to walk a straight line, or they may not be able to follow your finger. And then the cop at that point in time determines, oh, this person's under the influence of marijuana, take them to jail. So, there's just all these types of things out there. I've been told that there are products that are being manufactured by some companies to try to become sort of a breathalyzer to see and show what the level of marijuana in a person's system is and whether or not that person is under the influence. But currently, there is no such thing. Medical malpractice and negligence laws still apply. Nothing in this section shall affect or repeal laws related to negligence or professional malpractice on part of a qualified patient, caregiver, physician, MMTC, or its agents or employees. So, if you are a medical professional and you're at work and you improperly diagnose a patient or improperly treat a patient, whether that be in a nursing home or something, you can't say, well, I was under the influence of medical marijuana because it's legal. That's not going to get you out of it. You're still going to be prosecuted. You're probably still going to end up losing some of your privileges as a medical professional. And any other type of professional malpractice. Even in my profession, if I improperly show up to court and don't represent my client properly, I can't say, oh, I was under the influence of medical marijuana because it's legal now. So I'll still probably end up getting in trouble for that. So all other laws still apply, even if you do have the certification. Same here. All of the laws must be obeyed. Nothing in this section allows for the violations of any other law other than the conduct in compliance with these provisions under this section. This means that medical marijuana does not override any other laws in existence. So again, even if you've got certification, you still got to obey the law as it applies to pretty much everything else. Concerns. Residents or family members of residents that are in assisted living facilities and or other healthcare facilities. Private property rights of an ALF owner. Again, as I've spoken on this topic throughout the state, and I've spoken with a lot of healthcare facility owners, most are opting not to allow residents with the certification to be in their facility because they are afraid of the liability. It is very, very challenging to the owners of these facilities because a lot of times their residents receive federal funding which pays to keep the lights on and pay the employees and all of these things. And again, because marijuana is still illegal federally, they're afraid to rock the boat with Medicaid and Medicare and other forms of insurance. So therefore, a lot of times these owners of facilities, nursing homes and so forth, they're just not allowing people, to enter into the facility because they're just afraid of what could come back from that. And again, Amendment 2 did not repeal any other laws requiring laws or regulations. What that also means is that a lot of assisted living facilities and other healthcare clinics throughout the state, they're either, if you have employees that have the certification, they're just not hiring them, they're either terminating them because they don't want them in the facility. And that's what a lot of people are opting to do because of the stigma and because of the unknown. And I understand that a lot of times it just really boils down to business. Am I going to potentially lose money to keep my facility open? So they just say no. I think in the future there probably will be facilities that advertise themselves as marijuana friendly. And so there are facilities that I've talked to some folks around the state that are thinking about if it's 100% private pay and there's no Medicaid, there's no kind of federal dollars or anything of that nature that are coming into the facility, the risk is to minimize at that point so that there's no issues whether or not you're going to lose money. Applicants for employment with your ALF, again, Amendment 2 states there's no right to be accommodated by your employment. Drug-free workplace law still applies. Yeah, everything else still applies. I'll give you an example. I spoke on this topic and I had a lady come up to me and she said, my daughter has a card and she applied for a job to work at Carrabba's and they did a drug test on her. First of all, I was surprised that Carrabba's drug test their employees. It's like she was a server. So she was really upset that her daughter didn't get this job at Carrabba's. And I said, well, here's the issue. Carrabba's is a national chain. And once you cross state borders, you get into interstate commerce, and they're probably like, no. So she didn't get the job, and so I just said, try and have her look someplace locally. But yeah, it's not discriminatory at this point in time under ADA. So all other drug-free workplace laws still apply. Investors in ALS. Under federal law, it's still a crime. Banking and taxation issues come up. civil liability, negligence, professional malpractice lawsuits all still apply. As also has been explained to me a lot of times that if you're looking to open up a clinic, even some of the MMTCs and medical marijuana treatment centers and so forth are having issues even opening up, getting a lease agreement to open the business because the landlord doesn't want to get into marijuana. And so a lot of times I'm hearing that banks are not willing to loan money to these individuals because they're regulated by FDIC, which is again federal. And so you just get into this whole thing about whether or not you're going to be able to borrow money from a lending institution, as I see there's a bank here. I'm not throwing you guys on the bus. But there's just a whole other host of issues. I hope in the future, throughout my learning process of this, that federally it just becomes decriminalized and all of this hoopla kind of goes away. So again, I'm running out of time. So if you have any questions, please reach out to me. Rick Strong, Tom Buchan, my assistant, my associate is here. We're free to answer questions. Thank you.